One of the things that's such an important aspect of our journey as parents is making plans for our children, and they can be different, these plans, than they are for a standard trajectory of a typical child. We're really delighted to have Susan Katzen here with us today. She's an attorney, and she specializes in many things, but what really is key for us is that she specializes in helping parents of children with special needs, whatever the age of that child is, because of course children grow up. Our child is now 14. They just keep doing that. So I'm very excited to hear what you have to say, and will all of you join me in welcoming Susan Katzen to tell us about how to avoid some mistakes. Welcome, Susan.
Can you hear me? I'm not great with the microphone. I usually have got a pretty loud voice anyways, but I want to make sure that I can talk over any of the kids so that they can stay in and listen as well. So thank you for being here, and hopefully this will provide you with some really important information for you and your family, and particularly for your child, because it's really important at this point in time to start thinking about how you are going to protect them and plan for them when you're not here. So today we're going to look at some of the most common mistakes, and I've been in practice for quite a long time, so if I haven't seen it yet, it's going to be pretty unusual, but these are going to be the most common ones, and we'll talk about them in a relatively quick fashion. I want to give you the opportunity at the end to have some questions and answers, so if you can hold off so we don't go down a rabbit hole, because I'm real good at falling for a question and getting off topic. So probably the biggest mistake that I see is parents not planning. And the problem that you have with that is, doesn't matter what state you live in, if you don't plan, you're going to have a probate. And what that means is that you're going to have your state's court go ahead and decide who's going to take care of your child, who's going to get your assets, if there's going to be a guardianship or a conservatorship over your child, who's going to pay for things that might be a court-supervised type of protective proceeding. And in the long run, you might have a significant amount of expense just dealing with ongoing court supervision and jurisdiction over the years, where if you did some planning, your child would have access to additional funds. So, solution to the problem is start thinking about it. It's not easy. I mean, it is sometimes depressing, but it's reality of life. You will be doing yourself and your child a big favor. Take out a pencil and paper, identify what your goals are, what your needs are, and then start looking at what the needs of your child are so that you have something in place without having to go ahead and go to court. Always going to be expensive in court, always going to go ahead and be something that is not what you are probably going to want. Second one is disinheriting your child, and that was a real common concept that people used years ago, but as time has progressed, particularly since the 80s, they have really gotten away from this because it essentially doesn't provide any protection. I still do see attorneys that do this type of planning. So when you disinherit the child still is going to be eligible for needs-based government benefits. But no matter what state you live in, the federal benefit rate for SSI is $750, and that's got to pay for everything. If you live in California, that's not going to get you much. I don't think that any state, it's going to be able to cover all of your expenses. So you really want to look at doing something that's going to provide some instructions for advocacy and take your child out of that realm of being a ward or subject to government life, because it's really not going to be fun. There's going to be no extra funds available for anything other than maybe the basic needs. So what you want to look at is a special needs trust, because that special needs trust will also go ahead and protect the government benefits. But what it will do, in addition to that, it will provide supplemental funds so that your child will have a higher quality of life. You can provide for advocacy, you can provide for additional therapies, you can provide for systems of checks and balances, all sorts of things that are important to your unique situation in your special child. Similar to disinheriting, your child is going to be giving it to another trusted person. Typically that would be, I'm going to leave it to my other child, they're going to take care of Johnny, life is going to be good. There are a multitude of problems that go along with that line of thinking. First thing is that's a moral obligation, not a legal obligation, so it's not enforceable. Two, it has very, very significant issues that arise that would go ahead and impact the child with the disability's assets. So if the trusted person, sibling, whatever, passes, it's going to go to their heirs unless that sibling has done specific planning for your child. It will be subject to that trusted person's creditors, can also be used and divided on divorce. So really it doesn't have too many more positives than going ahead and disinheriting the child. And actually I think the bigger negative is that if you are having a sibling or somebody else in charge of your child, now they've got to go ahead and ask somebody for money that potentially could go ahead and impair their relationship. So again, you would want to look at using a third-party trust. It's going to set out your specific instructions on how you want things handled. So if it is a sibling that is in charge of the funds in that trust, it's going to be distributed pursuant to what you've provided in guidelines, and it's not going to be subject to their creditors. In fact, it's going to protect the benefits, so they'll be able to get benefits. It will go ahead and protect your child from any type of predators, and it will protect it from any creditors of your child's sibling. You also go ahead and, again, minimize any burden of family arguments or disagreements between your child and their sibling, cousin, aunt, whatever, because when you're gone, what you really want to look for is to make sure that that child has as many people loving them, caring about them, and watching over them as possible. We often see parents use what we call a one-size-fits-all trust. And what that is it's pretty much standard form language. And it might cut it, but might is taking a pretty big chance when you're dealing with a child with disabilities. What you really want to look at is something that's got customized language, because each child is unique. And if you have two children, you're going to know and understand what I'm talking about, that there's a great difference between just your two children. So you want to address any type of uniqueness that your child has, you know, so that you can best provide for them when you are gone. So a big part of what happens is we see the distribution standards are inappropriate. So what might work for my child might not work for your child. To give you an example, many trusts that are one-size-fits-all will have a distribution standard that says my trustee can pay for my child's comfort, health, welfare, and benefit, which I think that sounds great. We all want whatever it's going to take to make sure that that child has a happy and productive life. The next trust might say, my trustee can pay for anything as long as it doesn't go ahead and interfere with any government benefits. Well, that means that they can't pay for any food, shelter, or clothing, and potentially in some states that would go ahead and include other elements that they could not go ahead and pay for. So if they can't pay for any food or shelter here in California, where are they going to live on $750? It's going to be not in a very safe or clean place. So you really want to be careful with just grabbing the run-of-the-mill trust, because what seems like an okay sentence, if you're not sure, it's going to have a significant impact, because your trustee will breach that trust. The only way that they can go ahead and fix that is by going to court. So let's take a look at what some of your options are when I talk about customize. So you've got a choice between having a trust that's revocable or irrevocable. Now, you really don't need to go down the road of having an irrevocable trust unless you have so much money that you have a taxable estate. You really want to have something that's revocable so you can change it, you can grow with your child. As your child continues to age, different things happen. You want to be able to address those needs, address the varying people that are in there, address the changes in the law. So you want to keep it revocable so you can manipulate it to continually fit what works best for your child. Standalone versus testamentary. I always recommend a standalone trust, which we call a living special needs trust. And that means that it's a special needs trust that comes into existence on the date that you sign it. Whereas a testamentary special needs trust doesn't come into existence until you, the parent, are deceased. The importance of having one that comes into existence now is you get to test drive it. You don't buy a car without going ahead, making sure the windows work, looking and seeing what the ride is like. You don't buy a house. Why would you ever go ahead and create a trust for a child who you infinitely love without going ahead and trying it out to make sure that you understand what it takes to make it operate, you understand what your successor trustees are going to have to go through. So good way to go ahead and really be able to take it from being a document and into being something that is going to be a lifetime experience for you while you're alive and healthy and well, and for your child once you're gone. So when you talk about a special needs trust, it's like we got to protect the government benefits. And certainly government benefits are important. And really the benefits that you are looking at protecting are going to be the needs-based benefits. And the needs-based benefits are going to be supplemental security income, or SSI, and Medicaid/Medi-Cal, depending upon where in the United States that you live. Medi-Cal is almost always going to be critical because of the services that it provides in addition to medical coverage. SSI oftentimes is really the icing on the cake because, as I said, the federal benefit rate gives you $750 per month this year for food and shelter. So not a whole lot, better than nothing. I would never tell you not to go ahead and do it, but you have to understand the little strings that are attached to it. What you want to look at when you're doing your planning, though, if you're doing a trust, you want to take a look, what's the purpose of the trust? Well, we want to have government benefits, but is that the primary purpose? Probably not. You probably are looking for, how am I going to provide for my child? What is going to be the source of advocacy? What's going to be the source of the financial and fiscal management? Who's going to be there to have a system of checks and balances so I can make sure that his or her needs are being met and that everybody is doing the job that we set forth in our memorandum of intent. So you are going to want to start by envisioning what you want for your child in the future. You're going to address such things as, where are they going to live? Who's going to be taking care of them? Are they going to need a conservator or guardian? Are there going to be any medical challenges that there will be in the future? Who are the important people in your life or in their life that you want to have continue to be involved into the future? once you identify the desired lifestyle that you want for your child, you're going to need to make some estimates to see if you have enough money to go ahead and make that desired lifestyle work. And how you're going to do that is you're going to take a look at what are the potential sources of income that your child would have. Look at SSI, SSDI, Social Security, rental income. You might have rental properties, dividends from investment accounts. After you determine what the income is going to be, then you'll want to look at what are the expenses. So those things would be food, shelter, clothing, education, recreation, social activities, medical, anything that you can think of. And that list can get pretty long and pretty comprehensive. So you want to start it now so that you can every year update it, look at it. Now, the shortfall, the difference between the income and expenses is going to be what you're going to fund the trust with, and we're going to talk about that a little bit later. But when you are envisioning your child's future, what we're really talking about is the starting of what we call creating a memorandum of intent. And what a memorandum of intent really is a long, detailed explanation about your child. And it's going to be important that you update it every year because things will change. Your child will change, the people will change, the needs will go ahead and change. So you want to make sure that it contains ample information about your child's unique personality, strengths, weaknesses, the things that you feel that are needed to be addressed for medical, recreational. What are your goals about education? What are your ideas on work in the future? And you're going to put this all in writing, and there is no particular format. Some of my clients will go ahead and do an outline. Others will write long paragraphs. So the important thing is actually sitting down and doing it, because if something happened to you today, who's going to know where do you get the medicines, who are the doctors, who's the dentist, how often do you order diapers, where do you get the best deal on the diapers, how often is your child having seizures? You know, what have you done? What medicines are they taking? Where do you get the medicines? So all of these things should be contained in there so the next person can pick this up and have an idea of where to start. The same thing with the expenditures. You know, you don't have to go and have money inside of the living trust if you have it in place now, but what you're really looking for is a baseline, a starting point, so that if something did happen, somebody's going to say, oh, I can tell, I know this is what we spent on durable medical equipment. This is what they spend on food and shelter. This is what the cost for care is, which can be significant later on in life, because if you're not here to provide for that child, you've got to factor in who's going to be there. So you really want to have an idea of what these numbers are so that you can do some good planning. So anybody here, if they had a heart problem, would anybody go to their dentist? Didn't think so. So what I'm suggesting to you is when you're looking at special needs planning, you really want to go to somebody that specializes in it or focuses on it, because they are going to take what you need and what your child needs, and they're going to help you develop a plan. A trust is a document. You know, it's nothing more than a legal contract. What you really need to have is a plan for the now and a plan for your child in the future, something that is going to go ahead and work, something that's going to be effective, something that meets your goals and your child's needs. Yes?
So if you draw that up and you decide to change the person that's going to be taking care of your child, is that something you have to go and redo, get notary, or can you yourself change the person, or can you list in succession of order
So we're going to go ahead and get to that probably in about 2 slides. But yes, you can go ahead and if you're looking at the person that's going to care for your child, depending upon which state you live in, you're either going to have a guardianship or conservatorship. So that's actually going to be a legal designation unless your child has capacity, which if they're a minor, no, they're not, and later on in life, they might not have capacity. So the court would actually appoint that person, so you're not going to worry about that. What we're going to look at as far as inside of that document is you're going to create your village. And we're going to take a look at that village in a little while, so you can create the mechanisms so you don't have to go to court, so you can go ahead, and I always tell people, come in once, look at how we change it. Next time you need to do it, you got a really good sample, just copy mine. So you really want to look for somebody that's going to tell you, you know, what can you do, what can't you do. We do a lot of trust administration, so we see the back end, what doesn't work. So I've been doing this long enough, and I always start out my new staff and say, hey, you're going to start out in the trust administration department, because if you want to see everything that doesn't work, that you never want to have inside of a document, this is the best place to go ahead and do it, because you will become a very good drafter. The other thing that you want to do is you want options to, you know, get out of jail or pass go if you look at Monopoly, because you don't want to go to court. Court is really expensive, very expensive. And anytime something gets filed, all of your information or your child's information is available for people to look at, because it's a matter of public record. So you really want to try and, when you're doing this, you want to come up with your plan that's going to include your people that you want or you think you want now, but ways to get rid of them if you look back and say, oh, I made a mistake. You want to have an out. That's what's critical. You want to have an out. The other thing that you want to do is you want to go ahead and include other people in your planning. And if you tell people, Mom and Dad, I created a special needs trust for my son so that he's going to be taken care of when I'm not there. Here's the name of the trust. Well, if Mom and Dad were going to leave something to the child, they now have the name of the trust that they can leave it to. If they leave it to the child individually, it will cause them to lose government benefits. It will also potentially force a court-supervised trust, because if your child is a minor or doesn't have legal capacity later, they can't go ahead and hold on to property or assets. So it really assists in doing a little bit better planning. What we recommend, or what we give our clients, is we give them a letter, identifies what you've done, identifies what the name of the trust is, why we've done it, and how to go ahead and name the trust in their own planning documents. But think about this, which is if your parents have named you as a beneficiary, and you're thinking, okay, my parents have named me, no big deal. If something happens to you, where the hole is if it goes to your heirs. Because if it goes to your heir is going to be your child unless that special needs trust is named. So you do want to go ahead and coordinate with other people. If you love your child, your parents are going to love your child, and so are your siblings. And it's a pretty easy conversation to have, because your child is special, and you're never going to know when he or she is going to touch somebody else's life as well. And by hiding it or thinking it's unimportant or thinking that it's not going to matter, I will tell you that you are so wrong, because over the course of the time that I practice, I tell people, you got to do this. They all go, no, I'm not going to do that, or some of them throw my letter away. But we've got a handful of cases over the years where somebody else has decided to leave this child money. And probably the best story was, lady came in, we did it for her son. I've got siblings, they all have kids, nobody's going to get anything, so I'm going to throw the letter away. And I said I wouldn't do that, but she did. So probably 5 years after that, she called. My neighbor wants to go ahead and put something in Keith's trust. What should I do? I said, have his attorney call me or dig that letter out of the trash, okay? So the attorney calls, we name the trust, 5, 7 years go by, and the neighbor dies, and they left Keith $750,000, which we never expected. We thought a couple thousand, but it was for no reason other than the attorney that handled it said he just made a difference in this crotchety old man's life. And so you never know when your child is going to make a difference. And Keith wasn't somebody that could run around and talk and do a whole lot because that just was, he was profoundly disabled. But there were things that he did or ways that he smiled, whatever it was, that touched this person's heart. So don't ever discount it. You know, you spend a lot of time with your child and you probably don't realize just how much they are impacting the other people that they run into in such a positive way. So you can write your own letter. If you decide you want to see one, you know, you can call my office and we'll gladly send you a copy of what we do. But I do encourage you, if you do any planning, to make sure that you do let your family and friends know so they can address their own planning and not cause something to happen that would be detrimental from a benefits perspective. Okay, let's talk about the management team that you brought up. While you are alive and well and healthy, you are going to be acting as the trustee of your own trust. However, at some point in time, there's a good possibility you're going to become incapacitated. People are living longer nowadays, and oftentimes they become incapacitated before they pass. So you want to have a successor trustee. In fact, you want to have multiple successor trustees inside of your planning, because otherwise you're going to end up in court. So what becomes important is understanding who do we have to have and why do we want them, and really working through some of the options, because it sounds like a lot of work to create a village, but you know, we do it all the time, and once you bring a list of whoever it is and we start adding on to it, all of a sudden, you know, you've got a whole community there that's going to be available. So understand, trustee can be in anybody. It can be a child, it can be a bank, it can be a friend. I've got all sorts of opinions on why things would be better one way or the other, but what really matters is your unique situation and how it's going to best address what you want for your child and what your child needs in the future. So the trustee is going to make the distributions, manage the funds with the assistance of a financial advisor that they will hire. They're going to file all the tax returns, they're going to create a budget, they're going to go ahead and understand the government benefit rules, okay? So some people want their children, works. Don't have a problem with that. Other people want to put their kids on the Trust Advisory Committee. Trust Advisory Committee is a group of people that are there to assure that your child has their needs being met. It's a method to go ahead and get rid of that trustee. If that trustee goes south on you, you want to be able to get rid of them without going to court. So you can have your Trust Advisory Committee get rid of the trustee, remove and replace the trustee. They're a good system of checks and balances, so they're going to be watching the financial objectives as well as the budget, as well as any expenditures that are being made, so they get an idea if somebody is skimming the funds from your trust. You know, you've got somebody else that you're just turning over your entire net worth to take care of your child. You have to have a little bit of oversight. And then you're going to have a trust protector. Trust protector is, every time we get a new president, we've got changes in the law. And you want to make sure, particularly since we're dealing with government benefit laws, they change as well. We just had major changes in SSI laws May of this year, the end of May. So you want to be able to address those, again, without having to go to court. So you can switch and give your trust protector some trust advisory committee duties, vice versa with the trust advisory committee, allowing them to do some trust protector things. But you really want to have additional people to go ahead and look and manage so you can stay out of court, so you can get rid of somebody that you thought was great who turned out to be just totally wrong. Okay, let's talk about predators and creditors. If you go through a probate, anytime that any paperwork is filed with the court, beneficiaries have to have their name and address and notices given. So people search these court records day in and day out. If you've ever filed a probate or been involved in one, you know that the realtors are over there. Hey, does it, they want to sell the house? Do they want to sell the house? You've got financial advisors that are calling as soon as we're filing accountings and we've got money inside of a trust administration for a special needs trust. And that's because they hire people to access all the records. They probably don't even have to go down there anymore with modern technology. So you really are at a loss because people see money and they're looking at maybe a child with disabilities, and so they're a great target. You know, the disabled and the old people, they're both, somebody that is very prone to being taken advantage of and unduly influenced. So when you use a third-party special needs trust, think of structured management. What you have is the structure trustee distributes funds based on the instructions that you specifically set forth. How you want it, when you want it, why you want it. You've got your methodology for going ahead and replacing that trustee if they become sick, if they become incapacitated, if they become just a bad person. You've got your methodology for that. So you've got your next set of people. You've got your trust advisory committee or your trust protector as well. So you've got protection there. You've also, because the beneficiary does not have the opportunity to make those distributions themselves, you are actually protecting them, one, from themselves, two, from any predators and creditors. And by doing so, you're preserving the assets so that they will have funds available to supplement their needs for quality of life and to pass on to their heirs or your heirs. Failing to properly fund and maintain the trust. Take a look at the trust and think of it as a car. What makes a car run? Gas. So what's going to make your trust run is going to be money. And we talked just briefly about how do you determine what that amount of money is. And I can give you the ballpark, whatever the difference is between the income and expenses, that shortfall is going to be what you fund it with. But it really comes down to more. You need to go ahead and look at, how am I going to divide my assets if I have more than one child? Do I have enough money to go ahead and put inside of that trust? What additional expenses am I going to have? And so financial advisors will really assist you with helping you put things in perspective, particularly one that has experience in dealing with children with special needs. So they're going to look at things a little bit different. They're going to run scenarios. They're going to be able to tell you, it's not that we're going to be doing risky investments because we know that we can't afford to lose a whole lot of money because this is going to last the lifetime of your child. So they're going to help you bucketize, look at, are we going to need money to pay for long-term care? Are we going to have a lot of caregiver money? Maybe we might have to get an insurance policy. Is that insurance policy going to be second to die? Is it going to be a term policy? What's going to fit best with your unique needs and your child's unique needs? Same thing with an attorney. You're going to come up with the list of what do we want for our child and how do we go ahead and get there? What is going to be the best method to make sure that our goals are realized? What I would recommend for all of you is to go ahead and make sure that you've got some health care planning in place for yourself now. Because if you don't, you're going to be in court or somebody's going to be in court on your behalf and you're going to have nobody that's going to be there advocating for your child. You really want to go ahead and get some of your basic planning in place, which is going to be Advanced Healthcare Directive or Healthcare Power, depending upon what state that you're from and your HIPAA, so that somebody else can help make decisions for you, but they're probably going to be the next person in line that would be able to assist with at least making some immediate decisions on your child. So what you want to do, once you establish your plans, you want to look at maintaining them. Think about your estate plan every 3 to 5 years. Special needs depending upon exactly where you are with your child. And are you retired? Are you working? Are they stable? Are they adult? Are they minor? That timing is going to change. So the older they get, the less frequently that you're going to need to change it. But what you want to look at is, I want to go ahead and do it when there are major times in their life. You know, they're going to graduate from school and go to college, or they're going to be in a transition program. So they're going to have different financial needs. So you'll change or look at changing things, you know, review it. Probably when they get 18, 17, 19, around in that area to see, are all of my people correct? Do I still have the appropriate needs in place? Are we meeting our financial goals so that we've got that gas inside of our car? We want to make sure that we're doing our tune-up so the windshield wipers are working, the tires aren't bald, etc. So it does require a little bit of maintenance, but nothing that you can't really do on your own. Any questions? Okay, I'm going to, oh, yeah.
Part of the reason I was asking that question, I'm sure a lot of people have older siblings, is, you know, if you have an older sibling, 18, 20, your desire would be that they take care of their sibling. But if that doesn't happen, so is there, is he, would it, if the brother or sister wants to step forward, they can, if they can't, then it's just not working.
So when you're talking about caring for the child, you're talking about taking charge of the money. Just
Taking care of the child, taking care of the money.
so to go ahead and so he asked, what do you do if your if you want your child to take care of the finances as well as take care of your child with disabilities, if one of your children wants to do that. And so the answer is, you are going to have legal authority, or your child will have to have legal authority to make any type of decisions, no matter what state it's in. You know, you get by for a little while with doing nothing, or he can or she can get by for a little while, but you don't want to take that kind of risk. So they will require a guardianship or a conservatorship, depending upon what state you live in. California uses conservatorships, East Coast uses guardianships, and then just depends upon where in the Midwest that you are that would go ahead and have something different. But that you will have to have somebody legally appointed. You can make the appointment, but the court has to approve it. So her question was, there's a financial commitment when you create a special needs trust and you want to update it annually, and do you pay for that? So you wouldn't update your special needs trust annually. You might look at it, but what you're going to update is your memorandum of intent. That's what you're going to update. That is not a legally binding document, but it is brought in and incorporated by reference into the document. So my daughter's best friend had an anoxic brain injury, so every year she writes a book for me. So I know where she buys her diapers, I know what medicines she is on, I know where she gets her durable medical equipment, I know the names of all of the care providers that are outside, I know all of the care providers that are inside, and then she, you know, talks about the things that are important. Ashlyn is very good at riding her bike, even though she's just starting now to go ahead and walk. So the different things that are important to Kelly and John have changed year after year when I look at these, and it gets thicker and thicker. But we all have computers now, so it's not such a difficult task. You probably, for the most part, most trusts end up lasting about 7 years without having to do anything. That's not to say you shouldn't look at it, because you do want to look at it. Remember, we're not talking about a document here. We are talking about a plan, a way of life, implementing something. Don't shove it on the shelf like the phone book. You want to make this something that is part of life. You know, what are we spending on him? It doesn't matter that the trust isn't paying for it now because it's got no money in it. What you're really looking for is the starting point. So if your kids have to go ahead and take over because you and your wife end up in an unfortunate automobile accident, they have something to walk over and start with. Because if it's too daunting, that successor trustee is going to walk in and say, I am not going to do this. They might have started out being willing to, but you got to leave them a roadmap. That roadmap is critical. Yes? Well, you are asking, okay, you are asking if you should finish your family and then create a special needs trust or do it now. Okay, so the answer is you should create the special needs trust now because you have a child with special needs, and then you'd be looking at doing your own estate planning. So with your own estate planning, you still can go ahead and address the needs of all of your children that you have, and then any unborn children, because you can go ahead and say, I want any children that I have in the future to have a trust similar to Mary's. And because if you've got typical children, you know, when my kids were little, I didn't have everything go out right to them. In fact, I still don't. They look at me as mommy from the broomland, because it's like, you know, I know that you're all in the financial industry, but I think that you just wait a little bit and you can get your money in pieces, and that works better so that they can blow it once and they don't at least have the opportunity to blow it all. So, but you really need to get some, just even some healthcare planning. My concern always becomes incapacity, because I deal with that all the time, and we're in court then. And the problem is that if you don't have anything, you've got people guessing what you want for decisions, and you've got people guessing, what are we going to do with your child? And that's not what you want. You know, an estate plan, a revocable living trust is really easy to go ahead and change, but you want to get some basic plans in place because life happens.
Cost, what's your cost? What's the range?
Cost,
5 grand?
depending upon what you're doing. If you're doing an estate plan, usually trust, you want to know what the cost is for a special needs trust? Usually starts at about $3,500. But we do our tax opinion letter to you, so we explain to you and to your CPA what type of trust it is, because it's a grant or a trust initially, which is way too complicated to start talking about now. But for your CPA, they want to know that. We give you the instructions then on what you can and can't pay with the government benefits, what your reporting requirements are, so that you really have, again, I'm just about a plan. There are a lot of people out there that will create it for a lot less, but to me that just...
It starts at 3,500?
Yeah, we customize it. So, you know, it really depends upon what your family needs. Yes.
To be clear, the SNT does not impact the SSI or the Medicaid our children are currently receiving?
So her question was, does SSI impact...
No, does SNT, if we were
Does-
to do it now,
Mhm.
impact the SSI or Medicaid our children are receiving right now?
She's asking if an SNT will impact the SSI or Medicaid that the children are receiving now. And the answer is, if it's a properly drafted special needs trust, it will not impact it. They will stay eligible. Okay. Is it California? Okay. Yeah. So the court system, they asked if they would follow the will if something happened. They did a generic will. The court system will typically follow it, but if you did something generic, you probably didn't put in things that you didn't give much information to go ahead and follow, and that's where you're going to have your problem. Is the court is going to look at who's going to be the best options for what is remaining, and that might not be what you have in mind. So at least I'd go ahead and do a memorandum of intent along with it so you can keep that and update it and know you're still going to go through a probate, even in Arizona. That's the court is, a will is probate, and so you right away are subjecting yourself to what the court decides. So you can appoint them, and they typically, in California, if you appoint somebody, the court will look at that appointment. But that doesn't necessarily mean they're going to follow it. They're going to have investigators out there. It's a whole memorandum of intent. Okay, and I'm going to let Nina talk to you real quick about the ABLE account so that this is a great way if your child is receiving government benefits that you have some additional options. And Nina is my very pregnant associate attorney.
Thank you, Susan. Hello, everybody. Okay, I'll go through this real quick. I know we're running out of time here. We're getting that look. Okay. All right, so the ABLE account, really neat tool that complements the S&T, the Special Needs Trust. ABLE stands for the Achieving a Better Life Experience Act. It was passed about 2014. Congress finally caught on that it does take a lot of money to go ahead and raise a child with special needs. Essentially, Susan and I, we were recently at a special needs seminar, and the gentleman who was responsible for drafting all the regulations at Social Security kind of referred to the ABLE account as like legal money laundering, because essentially this really awesome tool, you're able to circumvent the ISM deduction. That's the in-kind support and maintenance. And so essentially, in order to be eligible for this, the individual has to be disabled before age 26. It's a pretty easy way to prove the disability. One, either the child or the adult, they meet the Social Security requirements, or you're able to attest that a doctor can provide a disability certification. For the account, you're able to put in there up to $15,000 annually. In total, you're allowed $100,000. Anything beyond that, that would just go ahead and suspend the benefits. If the individual works, the individual with disabilities works, then they're able to contribute $12,000 more on top of that $15,000. Okay. And how do the distributions from an ABLE account impact the benefits? As I indicated, $100,000, it's disregarded. You could go ahead, but the thing is that, of course, $15,000 per year, you could go ahead and deposit in there. So once it reaches that $100,000, the benefits will go ahead and they will suspend until it's spent down. The Medicaid, also Medi-Cal in California, will only suspend if it goes over the state's maximum for the 529B plan. The contributions to the account are not considered income or resources. And the distributions from the ABLE account for what we call qualified disability expenses, which pretty much most anything falls under that category, as long as it's for the benefit of the individual with the disability. We always talk about maybe gambling would not be included in there. Okay. We have a really good example how this would work. So you have Cole, he's 25 years old. He receives SSI benefits $750 per month, and so he wants to move on his own, but his parents would want to help him. So one, what could happen is that the parents could pay Cole the $1,000 for the rent, but of course that's going to kick him out of his benefits, okay, because it's going to be a dollar for dollar deduction. The other option is to pay the landlord directly, but then that's going to be considered the in-kind support and maintenance, and so that will reduce the benefit by $270. So now here comes like the quote-unquote money laundering part. So instead, you could pay that $1,000 to the ABLE account, and then from that ABLE account, the rent is paid to the landlord. And consequently, there's no reduction in the SSI. So option 3 would be the best option. Okay. So the benefits of the ABLE account is that, you know, also the person with the disability is able to you are able to teach them like some financial independence. You know, if they do have the capacity to manage those funds. The ABLE account, again, is able to pay for any food or shelter without having to trigger that ISM penalty. And so over time, over a year, so that's $270 that you save each month, which accumulates to just over $3,000, which is a significant amount of money because, of course, these, you know, an individual with special needs, you definitely want any funds is definitely going to help. And the drawback of the ABLE account, though, is that there is Medicaid payback, Medi-Cal in California, as of the date that the ABLE account is established. And also, as Susan had mentioned earlier, you know, when you have an individual who is managing his or her funds in the ABLE account, you know, there is no protection from undue influence. So that's something you need to watch out for as well. And so this is just a quick comparison of pretty much everything that's been talked about today. I'm comparing the ABLE account to the third-party S&T Susan had talked about, and Medicaid estate recovery. And the awesome thing with the third-party special needs trust that Susan talked about, there is no Medicaid payback for that. Thank you guys very much. Any questions? Essentially, when you have a first-party, excuse me. Okay, the question was, what is Medicaid payback? Okay, essentially with a first-party special needs trust or with the ABLE account, once the individual with the disability passes away, then any Medicaid services received, or then that has to be paid out to Medicaid, and then whatever is left would go to the heirs of that individual. The third-party special needs trust is not subject to that. The theory behind that is that, you know, the funds in a third-party special needs trust, that's, you know, those are friends and family that are giving money to the individual with special needs, and so the government definitely wants to encourage that, and so they're not going to assess that account with that payback. It's just the first-party special needs trust. Those are funds that belong to the individual with the disability. Any other questions? Yes. The question was the amount of funds that you're able to deposit into the ABLE account. Can it just cap out at $100,000 one time, you said, and then spend it down? Yes, you can refill it. It just has to stay below that $100,000 because once it reaches above the $100,000, the benefits are suspended until the funds are spent down.